Assalamu alaikum, good evening. Welcome to another edition of Legal Ease on ITV. This evening our topic is the employment equity, fair and unfair discrimination. The purpose of Legal Ease, as you know, is to make the law as easy as possible. I've got a guest this evening from the CCMA, Kagiso Ntite, I hope I'm pronouncing your name correctly, who's going to tell us about the CCMA and employment equity and fair and unfair discrimination. Kagiso, thank you for making yourself available. Thank you for coming and assisting with employment equity. Can we start by asking you to just tell us a bit about yourself? What do you do at the CCMA? How long have you been at the CCMA? What are your main functions?
Thank you, Prof. Good evening to the viewers. I joined the CCMA in 2007 as a commissioner, as a level B commissioner.
All right.
And subsequent 2 years, in terms of the years, I went up to a level A position. Then thereafter, I was an acting senior commissioner at the regional office in Johannesburg office. Now in 2014, after the enactment of the amendments, especially the first amendment, Employment Equity Act, I moved to head office. So I became an acting senior commissioner of employment equity. There until 2016 in June. Then July, I moved into the new department, HR, as an employee relations manager, because the CCMA has had a long time, without an employee relations manager, and I moved there.
Thank you for that. Perhaps if you just tell the viewers a bit, because it clearly sounds like you say you were acting senior commissioner for employment equity. So employment equity is obviously a specialist field within the CCM, and not all commissioners deal with employment equity.
No, not all commissioners deal with employment equity, Prof. What happened was, after the enactment, actually even before, there was a system that was put in place that most of the commissioners were taken on training on the new amendments, even before the 1st of August 2014, when the Act was enacted.
Right.
So subsequent to that, I worked with those commissioners and we kept on training them group by group, in that even now, not all of the commissioners have been trained on employment equity. It's only those who are competent, who are found competent, because after training, what you do is you write an assessment, and we assess you as to whether are you competent to can deal with those cases. And only those who are found competent are the ones that deal with such cases.
Okay, so if any of the viewers have an employment equity problem, if any of the viewers feel they've been unfairly discriminated against, they know they can approach the CCMA, they are in competent hands. So perhaps if you start by telling us a bit about what are the rights and responsibilities of employees and employers. Because I think if we start with that, employers will have an idea, employees will have an idea. Because a lot of people are not clear on what employment equity is. We hear about employment equity, they hear about affirmative action, and they're not quite sure how it is. In fact, some people fear that affirmative action or employment equity is reverse discrimination, but clearly it's not that. So what are the responsibilities of employers and employees?
Maybe I should start with actually the purpose why we had Employment Equity
Excellent,
Act.
a good place to start.
And we have Employment Equity Act because the legislature wanted to redress and to correct the imbalances of the past. Basically, the purpose thereof is to try and promote equality, and also to come up with affirmative action measures, implement such so that those imbalances can be reduced. That is the main purpose of the Employment Equity Act. Now, in terms of the responsibilities of the employees, firstly, their right is not to be unfairly discriminated against. Okay. The one thing that sometimes employees don't understand is that you can be discriminated against, but it shouldn't be unfair. So they've got that right inherently so. So now what do they need to do when they come across acts of discrimination, of unfair discrimination against them? What they need to do is to try first and deal with the matter internally. It is their responsibility to bring such discrimination to the attention of the employer.
Okay, so if they feel I'm being discriminated against, they need to follow probably a grievance procedure, but at least make the employer aware that, look, I feel uncomfortable, I believe I'm unfairly, and I don't think we must forget to use the word unfairly discriminated against, because discrimination, we know, can be fair, but we'll talk with that about a bit later. But what you're saying for now is they need to bring it to the attention of the employer.
Yes.
Because sometimes the employer or people sitting in senior positions are not aware that junior employees or other employees are being discriminated against.
Exactly. The employers have that right to be made aware and be given an opportunity to address such situations, especially because with this act, it comes, the amendment, it comes with, in Section 60, it comes with liability of employers, that an employer can be liable for the acts of its own employees. So you can imagine if an employee is aware that is being discriminated against by somebody junior, there are senior people, but doesn't bring that to the attention of the seniors. And unfortunately, when it comes to the CCMA as a case, it comes as a case of the applicant who's referring against the employer. Now it's no more the junior.
Because it's not against the individual, it's against the employer.
Exactly. So it is important, especially in situations where there is grievance procedure.
All right.
It's not like we are saying we close doors for those small employers, because there are those one-man businesses where the employer would be an HR person, the employer would be a payroll officer and then an owner at the same time, and discriminating its own employees. So we are not saying we're closing doors to such kind of employment relationships, but where an opportunity is there to deal with the matter internally, try to deal with it before you can refer it to the CCMA.
Okay, so irrespective of the size of the organization, whether it's a one-man business, whether it is a major corporate, whether it's a medium-sized organization, employment equity would apply to them. There are probably certain clauses that don't, and we'll go into that in a little while. So both the employees, you're saying, and employers have certain responsibilities, and of course, with the responsibility come rights.
Yes.
Now, there's a difference between discrimination for promotion businesses, for discrimination for behavior during the normal thing, but there's also a dismissal that could be based on discrimination.
Yes, there is a dismissal that can be based on discrimination. Now, in terms of Employment Equity Act, such disputes of dismissal are excluded by Employment Equity Act. But the LRA, Labor Relations Act, still has that protection under Section 187.
Okay, so viewers need to be clear on this. If it comes to dismissal, viewers need to rely on the Labor Relations Act.
Yes.
But if it's discrimination that's not a dismissal, then it's the Employment Equity Act.
Exactly.
Okay.
Yes.
But there's a place for the Basic Conditions of Employment Act as well, in terms of...
Yes, it plays a big role, especially when it comes to the roles of and responsibilities of the CCMA in terms of the dispute resolution. It plays a very important role. If we can remember, Prof, previously, we didn't have the powers to arbitrate unless parties consent to arbitration. So most of the dispute would go to the labor court after conciliation.
In other words, it starts with conciliation at the CCMA, thereafter it would go to the labor
court.
Now there's a change. I think this is important.
Yes.
because this, as you said, the recent amendments brought this about. So tell us about that, because I think that's really important.
Now, currently, in terms of dispute resolution, Prof, if a person earns up to the threshold, and the threshold in terms of Basic Conditions of Employment Act is 205,433 and 30 cents.
Okay.
If you do not earn above that, then your cases can be arbitrated at the CCMA.
Okay, so the threshold again, 205,433 rands and 30 cents, that's an annual salary.
That's an annual salary, yes.
Anybody who earns up to that or below that can refer the matter after conciliation to arbitration at
to
the
arbitration
CCMA.
at the CCMA.
And if anybody earns above that, they don't
Then-
have an option, it has to go to the labor court.
The matter goes to the labor court. An option would be to agree with the employer to arbitrate the matter.
Okay, but that would be a voluntary
It's not
process.
exactly, it's a voluntary process. The employer can say, no, I don't want to arbitrate. But where an employer is willing to arbitrate, they can consent in writing and the case will be arbitrated by the CCMA. Now, in terms of sexual harassment, specifically, threshold is not taken into consideration.
That's important.
Whether you are below or above, your case can be arbitrated by the CCMA.
Okay, that's an interesting thing, because again, previously, above or below the threshold didn't matter.
Exactly.
Conciliation, thereafter, the labor court. Now, if it's unfair discrimination, but it's not sexual harassment, the threshold would apply.
Yes,
So if it's up to the threshold or below the threshold, it's conciliation and arbitration at the CCMA.
exactly.
If it's a sexual harassment case, then it's conciliation and arbitration at the CCMA.
Yes, and there's another interesting thing that also came up with the act. That is the appeal process.
Okay.
Previously, we didn't have that,
Right.
so you can appeal. You've got 14 days to appeal a CCMA award.
Right.
But then if you are above the threshold on all other grounds except for sexual harassment, you have to review the
Okay,
matter at the
because
labor
then-
court.
Okay.
Yes,
And that would apply to voluntary arbitration, obviously, if it's
exactly.
over the
Yes,
threshold.
yes.
Okay, then something else. We often hear people talking about equal work for equal pay. That would also fall under discrimination, because
Yes.
discrimination can be based on race, gender, color, sexual orientation, religion, on any arbitrary ground.
Exactly.
But specifically also in terms of pay discrimination.
Yes.
Some employees get
Yes.
paid more, others get paid less. They do the
Exactly.
same work, or discrimination based on gender. Women get paid less than men.
Yes, yes.
Or sort of, any of those things. So tell us a bit about that.
In terms of equal pay for work of equal value, Prof, it's actually issues of pay differentiation.
Right.
Now, as to whether the pay differentiation is fair or unfair, it's for the parties to establish that, to prove that. Now, the one thing that most of the employees miss is that when you bring a pay differentiation, it has to be linked to the grounds of discrimination.
Okay.
So now, in most of the instances, an applicant would bring a case, but when you want to hear as to the basis thereof, you find that there is no discrimination. Probably somebody saw somebody else's salary and just said, no, we came together here, your salary is higher than mine,
Right.
and therefore it's equal pay for work of equal value, unaware that you must link it to the grounds of discrimination. It can be on an arbitrary ground, it can be gender, it can be race, and so on, because we've got quite a lot of trends of discrimination. I think they can be about 20 or more.
Okay. On that, let's take a break. Viewers, we'll be taking a break, and please stay with us. After the break, we'll continue with our guest. Kagiso will talk to us more about employment equity and the role of the CCMA and what you as an employee or as an employer may do or can do or allowed to do in terms of the Labour Relations Act, in terms of the Employment Equity Act, and in terms of the Basic Conditions of Employment Act. Time for a break. Thank you. Viewers, welcome back. We're talking employment equity, we're talking fair and unfair discrimination, the role of the CCMA, and our guest Kagiso, who's at the CCMA, the expert on that. Viewers, we're going to ask you to call in. If you have any comments, if you have any questions, please phone in and ask our guest the question that you have related to discrimination, related to affirmative action. Kagiso, before the break, we were talking about pay discrimination.
Yes.
And we stopped for the ad. Could you tell us a bit more about that?
In terms of pay discrimination, like I've already said, that one is supposed to link it to a ground of discrimination and ensure that there's impairment of dignity.
Right.
Yes. Now, the issue is, it does not mean that when there is pay discrimination, it means you are unfairly discriminated against automatically. There might be reasons why there is that differentiation. And if there are valid reasons why there is that pay discrimination, it means that there is no unfair discrimination. So now, in terms of Code of Good Practice, of equal pay for work of equal value, which was enacted in June 2015. Okay. It outlines all the justifiable reasons that an employer can come up with to justify why people are being paid differently.
In other words, there may be valid reasons.
There may be valid reasons. Okay. There may be valid reasons. And the one other thing also, it puts a responsibility also on the employers to try and reduce such gaps if there are indeed unfair pay discriminations. And it will give you even all the factors that the employer needs to consider when determining also as to whether the work is of equal value, or the work is the same, or the work is substantially the same, in that people should be paid the same. So such factors are outlined there, factors such as your skills, your working environment or working conditions or qualifications.
Okay, so it could get a bit complex. And
yes.
Let's assume an employee believes that he or she has been unfairly discriminated against in terms of pay discrimination.
Yes.
The employee takes it up with the employer first, obviously. We said you need to file a grievance. Employer does nothing about it, or tells the employee, look, there's no discrimination. You know, you have to live with this. We've got valid. Employee then can approach the CCMA.
Can approach the CCMA.
Okay, tell us a bit about that process that the employee has to follow. Where does the onus lie? Does the employee has to prove? Because normally in a dismissal case, employee has to prove there was a dismissal.
Yes.
Employer then has to prove that the dismissal is fair.
Exactly.
Now, employee can show there's unfair, well, maybe not unfair, but there's difference in pay. Maybe it's not unfair. Employee believes that it's unfair. How does that work? Does the employee just have to show there's a difference in pay? Employer then has to prove it's fair, or does the employee have to prove that the pay is unfair?
Prof, it depends on the ground of discrimination. Anything that is on arbitrary ground, the employee has to prove.
Okay. In other words, he who alleges must prove.
He who alleges must prove. But once there is a ground attached, a listed ground attached to that, then it's the employer who's supposed to prove that the discrimination is fair.
Okay, so an employee can, for example, say, because I'm a woman, or because I'm a man, or because of the color of my skin, I'm being paid differently to somebody else.
And that will be based on a listed ground.
All right.
Now it will be the employer who's
Now it shifts
supposed
to
to
the
prove
employer
that
who now
it's
has
fair.
to prove
Yes.
that it's fair. What can a commissioner do? First stage is conciliation. That
The first
we
stage,
know.
yes, is conciliation. And the one thing first, Prof, is that the employees, when they allege arbitrary grounds, they've got a whole lot of responsibility to do of getting information, making sure that you bring the right information because the onus is on you.
Right.
The burden of proof is on you. And making sure that when we talk pay differentiation, there must be a comparator.
Okay.
And the one thing that I see employees do, they would compare with themselves with wrong comparators. You find that it's like comparing an apple and a banana. So you make sure that you compare yourself with the right persons. But the challenge in most cases that employees get is they are faced with a situation when they request information. In most cases, employers refuse with the information.
Okay.
And in terms of the Act, the employers have the responsibility to provide any relevant information that might be needed to try and resolve that matter. And in terms of the Act, Section 18 deals with the disclosure of information. And you read it with Labor Relations Act also, with Section 16 of Labor Relations Act. And in most cases, like for once, I once dealt with a case whereby I had to issue a ruling because I couldn't proceed with an arbitration because there is no information. And the employees know as to who their comparators are, but they are not given such information. But the one thing that the employees should understand is that they will not be given individual information, which is confidential,
Okay.
but general information. For example, if you say that I'm in this particular position, and there's a person in this same position but earning differently, they shouldn't expect that it will be an individual profile that will be brought to the table.
So, but how would that then work? Because the employer would then have to say, yes, somebody else's pay slip, or yes, somebody else's pay, but without naming that person.
Without naming that person.
But that person does the same type of work that the employee who brought the case, and show either that the pay is the same or the pay is different, as you said, but for a valid reason.
For a valid reason. Sometimes it can be people in similar positions, or let's say same positions. We are all managers,
Right.
but we earn differently.
Okay.
Yes.
But even for that, there may be valid reasons.
There may be valid reasons. There may be valid reasons.
Viewers, just a reminder, the number is on the screen, 011-086-7777. If you have any questions, if you have any comments about fair and unfair discrimination, if you have any comments or questions about affirmative action, please call in. We have the expert in the studio who could answer your questions. Okay, let's go back to now the arbitrator. You, the arbitrator, you've been through the conciliation stage, no settlement, you at the arbitration stage, you find that indeed there has been unfair discrimination. What can you as an arbitrator do? In other words, what are the remedies for the employee?
Now the Act has vested the CCMA with more powers than before. Previously, you would just compensate, and compensation would be calculated in terms of a person's salary. But with the new Act, it is not capped. It's not calculated in terms of salary, because previously it gave an impression that when one is discriminated against, earning more and the other earning less, you know, the calculation gives an impression that the one who's earning more is more impaired than the one earning less. But now it depends on the merits of the case, and it's not capped. However, it should be justifiable. It should be fair and justifiable. And that compensation is for the impairment of dignity.
Oh, so it's not to correct the salary, but the arbitrator
No.
can also rule that they must increase the salary to ensure that it's on par with the other person.
Exactly. I'm still coming
Yeah,
there.
okay.
Then the next thing is damages. Previously, we didn't have the powers to order damages, but currently we can order damages. However, the damages are kept to the threshold, which is 205,433.30. It is kept. So now, whatever loss that you might have suffered because of that unfair discrimination, even if it's over and above the threshold, however, the commissioner can only cap it at threshold.
Okay, I need to stop you there. Can I, sorry about, we've got a caller on the line. Assalamu alaikum, good evening. Caller, your question, comment?
Hello, Assalamu alaikum.
Wa alaikum salam.
Just a question here.
Yes, please go ahead.
Let me just put this thing up. Yeah, I'm working over 10 years for a company
All right,
as a contractor.
okay,
And, since the Marikana incident, business sort of slacked.
all right,
And apparently I was dismissed.
okay.
But I had no pension, no UIF or nothing. Have I got any valid grounds to claim from them?
Okay, we need more information on this, but we will answer this question, but just remember, this is not in terms of the Employment Equity Act, this is not discrimination. You're asking some other question, but let's talk about it. Can you just give us a bit more information? You say you were dismissed, but there was no pension and there was no...
Yeah, I was working as a contractor.
Okay.
But,
Okay, now we need clarity on that. Sorry to stop you there. When you say as a contractor, were you an employee or an independent contractor?
Okay, they say independent contractor.
Okay.
But I think the law states that if you work X amount of time for a company, then you're not recognized as a contractor.
No, that's not quite true. You can be an independent contractor forever. Do not confuse that with somebody who's an employee temporarily for, a month or 2 months or 3 months. The law was referring to that, but we're not going to go into those details.
Okay.
But in the case of an independent contractor, you in fact fall outside of the jurisdiction of the CCMA, outside of the labor legislation, and you need to find your solution elsewhere through the common law, through the employer.
Yeah. Can I just come in here?
Yes.
Okay, I was working through a labor broker.
Okay.
Through a labor broker who was part and parcel of the company that I was working for. They were sort of an umbrella body for that company. And basically my contract was with the labor broker, who then basically put me in employment with the parent body.
Okay, do you want to attempt answering that? It's not quite Employment Equity Act. I know maybe we're putting you on the spot if you say you'd rather not...
What I would say is that maybe you need to go to the nearest CCMA so that they can understand your situation. I hear that you were working under a labor broker.
Yes.
And you were dismissed by that labor broker.
Yes.
Now, all that you need to do is to go to the CCMA with all the information.
Yeah.
So that you can refer a case. And when were you dismissed?
In 2015.
In 2015.
Yeah.
It's a bit late in that you might be needed to apply for condemnation. However, I'm not clear as to whether you are aggrieved by the fact that you were not paid your pensions and your UIF. Is that what you are aggrieved about?
Well, no, there was no pension, and there was a pension which was optional. You see, so I didn't take the pension.
Yeah, because if you didn't take the pension, then if you haven't contributed to it, then you can't have the pension. But in terms of the UIF, if you were dismissed, you were supposed to have been given a UIF form and go to the Department of Labor to claim your UIF. And now for the UIF, you need to go to the Department of Labor. However, you can go to the CCMA if you want to pursue the dismissal.
Okay, all right.
Yes.
Thanks a lot.
You are welcome.
On that, it's time for another break. We'll take a break and come back. Viewers, please be ready with your questions after the break. Please be ready with your comments after the break. We will continue after the break. Viewers, welcome back. We're talking fair and unfair discrimination. We're talking about affirmative action, the role of the CCMA, but we're also talking about what employers can do. Our guest is Kagiso, senior person from the CCMA, an expert on employment equity, an expert on fair and unfair discrimination. And don't forget, if you have any questions, please call in. The number is on the screen, 011-086-7777. Kagiso, before the break, we were still talking about this, the role of the CCMA, but maybe let's divert a bit. What can an employer do? Everybody, okay, before you answer, there's a caller on the line. Okay, we've lost that caller. Is the caller still there? Have we lost the caller? Hello? Okay, looks like we've lost the caller. What can an employer do? Because we know in the past there was unfair discrimination. What can employers do to redress those wrongs of the past?
Now, the first thing, Prof, that employers should do, they should do an analysis of their workplace. An analysis will be on the profile of the workplace as to how unrepresented in different levels it is.
Okay.
And secondly, they should also look at their practices, look at their policies. And when they do that, they should do that in consultation with the employees or representatives of the employees. They must take them along to assist in the whole process.
Okay.
And
please go ahead. Yeah.
Sometimes it can also be done if it is found, when an analysis is done and it is found that, yes, there's unfair pay differentiations, then the employer can, through collective bargaining, try and close such gaps.
Oh. Okay, we've got another caller on the line. Caller? Hello?
Hello?
Hello, yes, go ahead with your question.
Oh, the question is that it's relevant for somebody to work as a team leader from 2009 right up without relevant payment.
It's not clear. The sound is breaking up. I'm not sure if you can. Did you hear what? Could you just repeat that, please?
Say again?
Could you repeat your question?
Okay, yes. It is that right.
Could I ask you to put your? It sounds like your TV is on in the background. Could you mute your TV or put your TV off in the background, please? It's interfering with the sound.
Okay, let me be far from it because is that right for you to work from 2009 up to today as a team leader, but it's not getting the relevant salary?
Okay, so he's been a team leader since 2009, and you say you're not getting the relevant salary. Could you explain to us what do you mean not getting the relevant salary?
Of course, she is still working at the first salary till now, and is not getting promotion in salary, but in work is getting promotion.
He's getting promotion, but not getting more salary. Is that what you're saying?
Well, I'm not understand why you don't understand me, because this person has been working as a team leader from 2009, getting the same salary.
Oh, okay. Now I understand. Thank you.
Okay.
All right. So he's been working as a team leader since 2009, hasn't gotten an increase since then.
And other team leaders, has she done a comparison as to whether other team leaders are paid more and the team leader position has more salary than what she was in?
It's a manager, acting
As a manager, oh,
manager.
hey, when manager.
Yeah.
Hey, you don't want to move fast.
Okay, let's go. But let's deal with something like this. There's somebody who's a team leader all along, doesn't get any increase. Let's deal with that alone, and not in terms of discrimination.
Okay.
Because some people believe there's a right to an increase. We know, of course, there's no right to any. Okay, let's talk about that.
And it depends, Prof, as to whether a person moved from one position, which was a lower position, and now it's a promotion to another level, which its entry level
Yeah.
of salary is different from the previous one. Because if that is the case, that the person is promoted, but there is no salary increase, and yet responsibility
Have improved.
has increased, then it becomes a bit unfair. You can even refer it in terms of the LRA, in terms of unfair labor practice.
Okay, but if the person remains at the same level, team leader continues being a team leader at the same level, there's no right to an increase.
There is no right to an
Unfortunately.
increase, unless if it was a promotion.
Okay, and the right
Yes.
thing then would be join a trade union, join a lot of other people, because only as a group can you strike to put pressure on employers, but an individual cannot do
No, an individual cannot put pressure, especially when it comes as an issue of a mutual interest in that you want an increase and not that you are entitled to something because you have been promoted to another level.
that. Okay, but now
It's different.
there's another caller on the line. Hello, assalamu alaikum.
Hello, assalamu
Wa alaikum salam, go ahead.
Alhamdulillah, how are you?
Alhamdulillah, go ahead with your question. Please put your TV off at the back and continue with your question. Hello, is the caller still on the line? It looks like we lost that caller. Okay, let's continue with that team leader. We've got a team leader
Yes.
for many years earning the same salary, but other team leaders get paid more, get paid increases. But this particular team leader doesn't. Then I presume the person has a case.
Yes, there will be differentiation, especially if they are performing same or similar work or work of equal value. Then there would be. However, remember, it has to be linked to a ground of discrimination. It cannot just be pure difference
Right.
with no ground.
Okay.
You need to show that you are being discriminated against, your dignity has been impaired on.
Okay. See, this often can get complicated for people. For example, two people doing the same job, same race, same gender, let's assume. So we've got a caller. Let's deal with the caller first. Caller, hello, assalamu alaikum.
Alaikum salam.
Gee, go ahead with your question.
Yes, ma'am. I've got a question. I've been working for a labor broker, right?
Right.
The labor broker was contracted to a big transport company, of which the transport company was contracted to a big retail company, right?
Okay.
And one morning I was asked to do a breathalyzer test, of which I refused to do. Reason being, first of all, it wasn't a company policy, and does the people of the retail company have the right to chase me away, right? And of which the transport company dismissed me on the same day, and my people, the labor brokers, retrenched me after that. I mean, is that legal to do?
Did you get the question?
I got the question. I got that question. It depends on the reasons for dismissal as to whether there's fairness or unfairness. However, if you want to challenge it, you feel the dismissal was unfair, especially given the reasons for the dismissal, all you need to do when you refer the case to the CCMA, you need to cite both of them, the labor broker and the transport company that dismissed you. And one of them will be held liable.
Okay, so the person, if the person feels look, we don't have the details, we're not sure.
Yes.
Maybe that dismissal was fair, maybe it was unfair, we don't know at this stage. What this person needs to do, go to the CCMA, file a case of unfair discrimination, and here we're not dealing with discrimination, we're dealing, unfair dismissal,
Yes.
must cite both the retail organization that chased the person away and said, we haven't got work for you, and the labor
employer.
broker
Yes.
who he says retrenched me.
Yes.
So must cite both of them.
Yes.
They will both have to then go to the CCMA.
Yes.
He will have to prove that he was
Exactly.
dismissed.
Yes.
They will then have to prove that the dismissal was fair.
Yes.
Okay. So if the person is still watching, that's what you need to do. Go to the CCMA, file for unfair dismissal. Okay, we're going to take a break again, viewers. When we come back, be ready with your questions, and we'll continue with fair and unfair discrimination. Assalamu alaikum and good evening. Welcome back. If you've just joined us, we're talking employment equity, we're talking fair and unfair discrimination. Our guest, Kagiso from the CCMA, a senior person from the CCMA, is here to answer any questions you may have. Please feel free to call in. The number to call in will be on the screen. And before we had a break, the number is 011-086-7777. Before we had the break, we were talking about sorry, we've got another caller on the line. Assalamu alaikum, good evening.
Hello.
Hello. Go ahead with your question. Go ahead with your question.
Okay, listen, okay. I've been working for a company for over 35 years.
Okay.
I turned 16 in 2013, okay?
All right.
And then I went to apply for UIF funding.
Were you dismissed?
No, I retired at 60.
Okay, you retired at the age of 60. Was that a compulsory retirement or did you choose to retire?
No, that's a compulsory retirement age for the company.
Okay.
Then I went to apply for UIF.
All right.
And then before the end of that month, I was called back as a contractor to the company.
Okay.
I worked as a contractor from 2014 right up to June 2016.
All right.
Okay, June 2016, I didn't feel well, and I resigned.
Okay.
All right, I went to apply again for UIF,
Yeah.
and I was refused again because I resigned. I don't qualify for UIF.
Okay.
So,
Okay.
Can you help me out there?
Yeah, look, this is the Department of Labor question. This is a UIF question. It's not employment equity. It's not CCMA issue. But at the Department of Labor, if you resign, then you're not entitled to claim UIF. UIF, if you've been dismissed, you can claim UIF because you need to be need to have been dismissed, either retrenched. Or previously when you were forced to retire, then you could claim UIF. Do you want to add anything to that?
Yes, or if you are on disability.
Or if your retirement or if you left because of a disability and you can show and you have a medical certificate and show that because of a disability, because of illness, I was forced to resign, then you can claim UIF.
Yes, I do have the doctor's certificate to say, well, yes, I was...
Well, then you need to make an application to the Department of Labor on the grounds that you were forced to leave work because of ill health or injury.
Yes.
They would then have to pay you the UIF, provided for those 2 years or 3 years after you left the company, because you also said you left and then you worked as an independent contractor. During that period, did you contribute?
I was on pension.
But did you contribute UIF during that period?
Yes, for the last 35 years I did contribute to UIF.
No, I'm talking about the last 2 years after you retired.
Yes, I did contribute there too.
Okay, then you would be entitled to it if you can show that you left on the basis of ill health or injury.
Okay, thank you very much.
All right, but you need to take your medical certificates with you.
Yes.
Okay, we've got another caller on the line. Assalamu alaikum. Good evening.
Evening, how are you?
Go ahead with your question.
You're speaking to Amanda. I'm calling from North Riding.
Yes, Amanda, your question, please.
Yeah, my question is based on performance bonuses. I'm working for an organization whereby bonuses were paid out to employees, but there are certain employees that were excluded from payment of bonuses.
Okay.
And unfortunately, there was no performance assessment done throughout the year. Only at the time when the bonuses were paid, the colleagues were told that they were not eligible for bonuses.
Okay.
Whereas there were other colleagues that were paid out 100% bonuses, whereas their performance was not audited, but there were irregularities in terms of the Auditor General.
Okay, we've got the question. Kagiso, you heard the question. Is there unfair discrimination? Is there unfair labor practice? Do you want to answer that question?
It's not an unfair discrimination. The way I hear it, the gist of the issue is the fact that there were no performance assessments that were conducted, but yet others were paid and others were not paid.
Okay.
However, if there's a particular ground of discrimination that can be proven, then she will be justified, or they will be justified to refer a case to say that because these ones were paid, we were treated differently, and on this particular ground, either because of race or gender or maybe any other ground. Or if it's not a discrimination, there isn't a ground of discrimination attached to that, then they can refer an unfair labor practice, the unfair conduct in terms of benefits.
Okay, because then unequal benefits.
Unequal
Viewer,
benefits.
if you're still there,
Yes.
or if you're still watching, if you can show that the bonuses were paid to some people and not to others because of discrimination, then you will have an unfair discrimination case, and you can take that case to the CCMA. And again, a reminder, if you were earning below the threshold, then clearly it would go to CCMA for conciliation, then arbitration. If you were earning above the threshold, then it would be the CCMA conciliation and then the labor court.
Yes.
However, if it is not discrimination, but you did not receive bonuses where there's other people received bonuses, then it's unequal benefits, then it would be an unfair labor
Practice.
then it would be an unfair labor practice.
Yes.
Okay. No, that is clear. I understand.
Thank you very much for your call.
Thank you very much for the answer.
Okay, let's come back quickly, and we don't have much time. We've got about a minute to go. Can you talk to us? We were talking about affirmative action when we got the calls, when we took the break.
Yes. Now, in terms of affirmative action, the employer must do a consultation, make sure that they've got the profile of the workplace. The policies should be in order. Correct those policies that might be discriminatory, because remember, discrimination can be direct or
Right.
indirect. And thereafter sit with the employees or representatives of the employees. Sometimes during collective bargaining, during salary increases, you can correct that.
Right.
The only thing is that the employer has the responsibility to show that he or she attempted to redress those imbalances and comply, especially with issues of employment equity plan, income differentials that are being submitted to the Department of Labor on a yearly basis. Make sure that you comply with that and ensure that if your income differentials have those gaps that show unfair discrimination, deal with that
Okay.
at the workplace.
But this would apply to certain employers and employees only, because we've got things like designated employers.
Exactly.
And this wouldn't apply to small
Designated,
employees or
exactly.
micro employees
Yes.
or the small retailer that we talked about
Yes,
at the
it's
beginning.
designated employers.
Okay, Kagiso, thank you for making yourself available. Thank you for having come to the show. It was really informative. I'm sure the viewers will agree with me. There's been some really important information. And like with all these, whenever we have an expert on the line, it's always difficult. We can't deal with all the questions. Hopefully at another time, we'll get you back to answer some other questions for us. Thank you very much for having made yourself available. And viewers, Assalamu alaikum. We'll meet again next week. Please tune in again next week and we'll continue. And hopefully we'll have another expert in the studio to give us information, to make the law easy for us, inshallah. And you can call in with your questions. Assalamu alaikum wa rahmatullahi wa barakatuh.